Good morning and good afternoon, depending on where you are, and welcome to this webinar organized by Africarb and Reed Smith in the context of the Paris Arbitration Week 2020. I'm very happy to welcome you today for a session on arbitration in Africa, the role of state courts. The session will be held in both English and French, so I will now turn to say a few words in French. Bonjour à tous, je suis très heureux de vous accueillir aujourd'hui à ce webinaire organisé par Africarb et Reed Smith sur le rôle du juge étatique et de l'arbitrage en Afrique, dans le cadre de la semaine de l'arbitrage 2020. Cette session se déroulera dans les deux langues, c'est-à-dire que chaque intervenant pourra s'exprimer dans sa langue. Les questions lui seront également posées dans cette langue. N'hésitez pas d'ailleurs à poser des questions. Nous tenterons d'y répondre soit durant le séminaire, et si nous n'avons pas le temps, nous vous répondrons par la suite. I will now turn to English, so sorry, I will try to go back and forth in the two languages so that everyone feel that it's really a bilingual session. So today's topic, the role of state court in arbitration in Africa. The idea behind the topic is obviously the fact that arbitration has multiple point of contacts with state courts, and we found it very interesting to look at these various point of contacts along the life cycle of a typical arbitration process, and to look at these topics and these contacts. We thought it was very important to embrace the diversity and of the state points of the African continent. And obviously, we don't have the ambition to present and cover today every aspect of what the continent is offering, that would be obviously much too wide for the two hours we have. But we try to cover various angles, various standpoints, geographical areas with our distinguished speakers. And the idea to bring together these speakers is really that they offer different views on these topics. I will now. So before we start, just a few comments on the logistic. So we will be addressing 4 topics today, one after another, and I will announce each of these topics. And for each topics, 1 or 2 or sometimes 3 of the speakers will present their position and the points they want to make. And afterwards, there will be a debate between the speakers and also open to questions. So again, I invite you to use the Q&A box you have on your screen to put question on us. I also have to say that the webinar will be recorded and that will be available afterwards on Reed Smith's website. And also a short notes summarizing the debates of today's debate will be produced and will be sent to participants. Without further ado, I will now introduce the various speakers, and starting with Leyu Tameru. Leyu is not on your screen, but she is online. She dialed in from Ethiopia. Unfortunately, she was not able to use the internet connection, which is actually currently cut in the country, but she managed to call us. We are very glad to have Leyu among us. So Leyu is a founder of IARB Africa, Africa's online international arbitration hub. She's an arbitration expert and regularly consults on international arbitration projects for private companies and governments. She previously worked with international private and government organizations, such as Wilmer, Coulter, Pickering, Hale, and Dow, DLA Piper, the World Bank, the IFC, and the African Union. She is experienced in private sector development, international arbitration, youth empowerment. And I must say that also Leyu Tameru is an ICC court member for Ethiopia. So welcome, Leyu, and thank you again for being able to join even by phone. Then we have Suzanne Kimani. Suzanne is the co-registrar of the Mauritius International Arbitration Center, the MIAC, where together with Mrs. Ashwita Ambast, she heads the MIAC Secretariat and administers arbitration pursuant to the MIAC arbitration rules. Suzanne also serves as legal counsel of the PCA, and as such, she acts as registered and tribunal secretary in international arbitrations, involving various combinations of states, state entities, international organizations, and private parties. Mrs. Kimani is qualified to practice law and as an advocate of the High Court of Kenya. Thank you, Suzanne, for being with us today. Now I turn to Abayomi Okubate. He's a senior associate and team leader in the international arbitration practice of Olaniyun Ajayi law firm in Nigeria. He has more than 11 years of experience in dispute resolution. Abayomi is a prime mover behind several important arbitration initiatives in Africa, and I will not mention every single initiative, but just to mention a few. He's a founder and president of the Association of Young Arbitrators, birthing the Africa Arbitration Academy. He's a co-founder of the Africa Arbitration, managing editor of Africa Arbitration blog. He's an alumni from the UCL in London. Abayomi also sits as an arbitrator in several arbitration in Nigeria. And last but not least, in February 2020, Abayomi was named one of the 100 most influential young Nigerian. Well done, because I guess it involves not only legal people, but more generally. So it's really an achievement. And I will end with Mamadou Konaté, et je vais parler en français. Mamadou s'exprimera en français. Mamadou est un avocat inscrit au barreau du Mali et de Paris. Il est ancien membre du Conseil de l'Ordre des avocats du Mali, ancien président de la Commission nationale OHADA pour le Mali et expert en droit OHADA. Il est l'associé principal et le cofondateur du cabinet Jurifis Consult, qui est un cabinet implanté à Bamako, Conakry, Douala et plus récemment Paris. Mamadou Konaté est l'auteur également d'ouvrages publiés récemment chez LGDJ, La justice en Afrique, ce grand corps malade, et le guide des procédures collectives OHADA. Je ne pourrais pas présenter Mamadou sans... je ne résiste pas en fait au plaisir de préciser que Mamadou a été garde des Sceaux, ministre de la Justice du Mali, ce qui résonne, en tout cas pour les Français, à l'actualité très récente, avec la nomination au ministère de la Justice d'un autre de nos confrères. Je m'arrête là et I will now turn to our speakers and to introduce the first panel, which is the role for the state courts before the constitution of the Arbitral Tribunal. And I will ask Leyu Tameru to start giving us some of her insight regarding that topic. Leyu, floor is yours.
Thank you very much, Clément. I want to thank you for the invitation and the Paris Arbitration Week, and particularly for accommodating me with the current challenges, the logistical challenges that we've been having in Ethiopia. So thank you. I'm also very grateful and honored to be on such a great panel. I'm glad we get to have it. I know with the current COVID challenges, it was unsure when the Paris Arbitration Week would take place, so I'm glad this is happening, albeit online. Now, to start off on my comment, and I'm very mindful of the 7-minute limit, so I will make sure I stick within that time. I want to start off with one thing, which is when we discuss the role of state courts in the Constitution of the Tribunal or before the Constitution of the Tribunal, we have to take into consideration two things, because we're assuming two major things. Firstly, is we know the seat of the arbitration, and that since we are focusing on African states in this webinar, we're assuming that the seat of the arbitration is in an African state. Now, as wonderful as that is, that unfortunately is not the practice very often. In international arbitration, governing rules would usually be rules by African states. Different, Ethiopian law, Nigerian law, Mauritian law, or whatnot. But having the seat be designated in an African seat is something that African states are actually still battling at the moment. So it's unfortunate, but there are very, very limited practices with regards to that. So the first thing that I've noticed with regards to, for example, the practice in Ethiopia, and in my work with the government and my work with certain companies, and particularly with government entities, state-owned entities, is the main thing that they require usually is that they would like to have Addis Ababa as a seat of arbitration and Ethiopian law as a governing law. And that is because obviously this is what is most familiar to them. Now, the foreign companies usually are quite resistant to this, but I've seen in many cases that there has been success where both the seats and the governing law would be Ethiopian law. Now, I'm going to start talking about a case that is not exactly an Ethiopian case, but would be a great segue and a great discussion point to the Ethiopian case that I will be discussing on this matter. Now, the role of courts in the constitution of the Arbitral Tribunal, or even before the constitution of the Arbitral Tribunal, is usually seen as, a time where there's injunctions to make sure that the arbitration is not happening, and it's kind of a battle point, and it's presented as such. But the way I would like to present it is as an opportunity, especially in 2020, where we're having this discussion of diversity in arbitral tribunals, how state courts can play a very pivotal role in creating diversity in that space. Now, the first case I will talk about, a non-Ethiopian case, is one that has been covered and discussed, I think, on a large scale. And it concerns my favorite rapper, Jay-Z, right? So in this particular case, the businessman was being sued, in an arbitration dispute concerning a clothing line. And the arbitration was to be held under the AAA, the American Arbitration Association rules. And according to those rules, what usually happens, the appointment procedure is so that the two parties would actually have to choose an arbitrator from the list of arbitrators presented to them by the AAA. Now, what happened is Jay-Z, being an African American, saw that there was actually a very small number of African Americans on that list. So what his team and his counsel did, and this could be a delay tactic, but I thought it was quite brilliant, particularly with regards to diversity, is that they got an injunction in court and claimed that he, as an American citizen, has a right to be judged by a jury of his peers. And the fact that there is a lack of diversity on the list given to him by the AAA was a clear indication that his peers were not present. So this ended up in Jay-Z providing the AAA with a list of African American arbitration practitioners that could be added to their panel, but also the court recommending that the AAA increase the number of African Americans on their panel. so that the diverse parties that come to them have the opportunity to appoint diverse arbitrators. Now, I think this is a fantastic point because this is a great segue to the Ethiopian case I would like to bring up, which is a case concerning Cellini versus the Addis Ababa Water Sewage Authority. It's Cellini versus Alpha. It's an easily also Googleable case, and the award is actually public and available online. In this case, this is a case that concerns a project, waterworks in Ethiopia. The seat was Addis Ababa, and so was the governing rule. It was Ethiopian law. Now, what happened in this is, after the arbitrators were appointed, 3 of which were European men, the parties expressed that they had witnessed, particularly the Ethiopian state-owned entity, expressed that it had witnesses that were coming from Ethiopia and that the case was actually very much an Ethiopian case, and that the place of arbitration, as designated on the contract, was Addis Ababa. And there was obviously a dispute on jurisdiction. So in the process of reviewing the jurisdiction point, the Arbitral Tribunal decided to have the hearing in Paris. Now, the Arbitral Tribunal used, of course, as per the ICC arbitration rules, its discretion to decide on where the venue of the arbitration would be. Now, this didn't sit very well with the Ethiopian party, with the respondent, and the respondent brought a claim before the Federal Supreme Court of Ethiopia, claiming that the decision to have the venue in Paris, while the contract said place of arbitration Addis Ababa, was one that, the Arbitral Tribunal overused its discretionary rights because, and it indicates bias because the party against which the dispute was is a European party. But while you have a case that concerns a project in Ethiopia, seated in Ethiopia, and governed by Ethiopian law, the party was unclear why the venue would be Paris. Well, this is an important point because experts are going to have to be flown out of Addis and whatnot. And in this point, I think, bias was what was alleged, but although that's a debatable point, and the Arbitral Tribunal decided to actually completely disregard the court case and the injunction, what was very interesting to review on this case was the importance of actually having a diverse panel, because had the panel had an understanding of how the law, the seat of Ethiopia, had the law of Ethiopia would be, then the panel would have had a better understanding of how to engage with the court and what the state courts are capable of based off of the law of the seat. And this is a very key point I would like us to actually underline, is if there is a vested understanding of the law of the seat by arbitral tribunals, then the rule and the law and the state courts role would be pivotal and would be really important and actually playing a positive aspect in the arbitration rather than it being seen as a nuisance. And the other takeaway is that, again, state courts can actually play such a pivotal role in creating diversity, which we usually put on the arbitration centers and the state parties or the 2 other parties, but the courts can actually play this really important role, and it is important that we have people use the state courts to be able to create diversity. So this is kind of my tidbit to start off the conversation. Thank you, Clément.
Thank you very much, Leyu. This is very, very interesting and insightful comment. Abayumi, do you want to make also some comments on that first topic?
All right, thank you. Let me start by appreciating the organizers of this session for inviting me to speak on this very important topic, which I think is an interesting one. I think the best way to start is to note that the roles of courts in arbitration varies from one country to another, and largely depends on the national legislations in the different countries. Now, the approach may differ from some courts jealously guarding their jurisdiction to some other courts fully recognizing the autonomy of the arbitral process. Now, under the Nigerian law, and I will be speaking more from the Nigerian perspective, the extent to which a court can intervene in arbitration matters is limited by the provisions of the Arbitration and Conciliation Act, which is the national law on arbitration in Nigeria. Section 34 of that act provides that a court shall not intervene in any matter governed by the act, except where so provided in the act. Now, this provision evinces the clear legislative policy and is an appreciation of the principle of party autonomy and minimal judicial intervention in arbitration. Now, the legislative policy has been giving judicial reinforcement in different cases. There are so many Nigerian authorities, judicial precedents that have, interpreted this section. And one of them is the popular case of Start Oil and NNPC. NNPC is Nigerian National Petroleum Corporation. I'll be referring to a lot of NNPC cases in the course of my presentations because they always have different disputes involving arbitration. Now, in this case, the court interpreted section 4, and the court said the intention of the legislature in enacting that section is to protect the mechanism of arbitration and to prevent the court from having direct control over arbitral proceedings outside the circumstances specified in the act. Now, put in a different word, the intention of the legislature is to make arbitral proceedings an alternative to judicial adjudication and not an extension of court proceedings. Now, as I understand it, there are 3 different situations in which a court may be invited to intervene in the arbitral process prior to the constitution of the tribunal. One is to determine the validity of the arbitration agreement, or for the purpose of appointing an arbitrator in circumstances where parties or the appointing institution fail to act, or where there's a need to get a preservative order prior to the constitution of the tribunal. And I'll unpack them one by one. At the outset of the arbitral process, the court will be called upon to determine the validity of the arbitration agreement and state proceedings. Now, this is typically the first point of call for a judicial intervention. So where a party to an arbitration agreement has commenced court proceedings rather than explore arbitration as agreed by parties. But the counterparty insists on its right to have the matter resolved by means of arbitration. It is the court's responsibility to ensure that the parties' agreement is enforced by referring them to arbitration. And this is provided for under sections 4 and 5 of the Arbitration and Conciliation Act in Nigeria. Now, section 4 of the Act provides that where an action has been brought before a court, arbitral proceedings may nevertheless be commenced or continued in parallel, and an award made by the tribunal in such arbitral proceedings will be enforced by the Nigerian court. And there are a lot of cases in Nigeria where arbitration clauses that have been held, arbitration proceedings that have been held in parallel with court proceedings, and award coming out of such proceedings have been enforced by the Nigerian courts. In one of the cases that I have been involved as a counsel relating to a power purchase agreement, one of the parties to the PP commenced a court action in breach of the arbitration agreement. And the Nigerian Federal High Court, while upholding the arbitration agreement, held that once an arbitration clause is retained in a contract, which is valid, and a dispute is within the contemplation of the clause, the court should give regard to the contract by enforcing the arbitration clause. Now, the only permitted situations in Nigeria where the court may not refer parties to arbitration is where the defendant has taken any steps in the proceedings, in the court proceedings, or he has expressly waived his right to arbitrate. And this is by no means a consistent practice in Nigeria, given the resentment of few courts, and I say few courts, some courts in Nigeria, to arbitration. And this prompted the former Chief Justice of Nigeria in 2017 to issue a directive requesting all courts in Nigeria to decline jurisdiction in any matter founded in the contract with an arbitration agreement, and to enforce arbitration agreement by referring parties to arbitration and award punitive costs against parties who are in the practice of breaching arbitration agreement. Now, moving swiftly to appointment of arbitrators, the court will have the powers to intervene in the process of appointing an arbitrator or on the procedure for such appointment. A decision of the court as a result of such intervention in Nigeria and under the Nigerian law is final and is not subject to an appeal. Such intervention may be in any of the following circumstances where a party, for example, fails to act as required under the procedure, or where the parties or two arbitrators are unable to reach agreement as required under the procedure, or where a third party, for example, an arbitral institution, fails to perform any duty imposed on it under the procedure. Now, as it relates to intervention of the court through granting preservative orders prior to the constitution of the tribunal, I will exemplify this with the recent decision of the Federal Court in Nigeria. The case is Atlantic Energy against Nigerian Petroleum Development Company. It is a subsidiary of NNPC. In that case, the Federal Court in Nigeria, while emphasizing the importance of judicial support for arbitration, held that being an order in aid of arbitration, it is to enable the arbitral tribunal to become seized of the entire proceedings and to decide for itself if it wishes to grant any interim measures of protection or any others at all, as the tribunal is empowered to do so under the Act and the rules. So these decisions and some of the recent judicial precedent coming out from Nigeria continue to demonstrate the current judicial disposition of Nigerian courts to intervention in arbitration before the constitution of the tribunal, and evinces what you're seeing in recent time, the minimalist approach of the Nigerian judiciary in the arbitral process. That is my intervention for now.
Thank you, Abayomi. We put the slide on, but we will be able maybe to put it again afterwards if needed. I will now turn to maybe the other speakers if they would like to react, although I would also have maybe questions. I see that Mamadou nous a rejoint. Bonjour Mamadou. Vous êtes en mute.
Oui, bonjour.
Bonjour. Merci de nous rejoindre ce matin. C'est un plaisir de vous voir. Abayomi et Léou ont pu déjà s'exprimer. Si vous avez des commentaires, n'hésitez pas à en faire à ce stade ou alors après. Et puis sinon, je pourrais aussi demander à Suzanne.
Non, je vais plutôt passer le temps de rentrer dans les échanges.
Très bien. Suzanne, do you have any thoughts, comments at this stage?
Yes, sure. Thank you very much, Clémence and all the organizers of this panel for the opportunity to comment on the various aspects of state courts and arbitration in Africa and give the Mauritian perspective. Just a quick introduction on the Mauritian law that I'll be referring to. Mauritius in 2008 enacted the International Arbitration Act that is based on the Arbitral model law as amended in 2006. And the Act has some various modifications to adapt it to the specific circumstances in Mauritius. But this Act exclusively governs international arbitration and leaves the realm of domestic arbitration to be governed by the Mauritius Civil Procedure Code. Now, with regard to the court's role when it comes to arbitration, the courts in Mauritius adopt generally a non-interventionist approach as provided in Section 2A of the International Arbitration Act. And one of the roles that I see in Section 5 of the Act is that essentially where proceedings are started in a Mauritian court and one of the parties contends that the action is subject to an arbitration agreement, then the matter should be referred automatically to the Supreme Court, which is mandated to hear all the arbitration applications under the International Arbitration Act. And what the court ought to do then is to refer the parties to arbitration unless it is demonstrated on a prima facie basis that there's a strong probability that the arbitration agreement is null and void or inoperative or incapable of being performed. And here the court's role is quite limited. It is not meant to engage in a full trial or indeed a mini trial of the relevant issues, just to engage on a prima facie review, which contains quite a high threshold for parties to reach for the matter to be referred back to the referring court. But in most cases, the Supreme Court will refer the matters to arbitration if on a prima facie basis then the arbitration agreement is operative. That's what I would wish to add on.
Thank you. And maybe a question for you, Suzanne. Then you mentioned the high court to which applications are directed. Are those judges specifically specialized in international arbitration or in arbitration in general?
Yes, thank you for that question. It was something that I was planning to address later, but I can address it now. One of the innovations of the International Arbitration Act is that it creates a system of designated judges of the Supreme Court. And these designated judges are 6 of them. They are nominated, they are appointed by the Chief Justice, and they are the ones who sit and hear all international arbitration applications that are made to the Supreme Court. These judges, this innovation was to enable all applications under the Act to be heard by specialist judges. So to answer your question, yes, they are specialist judges because they have accumulated knowledge from hearing all international arbitration applications. But in addition to that, they also receive training on international arbitration here in Mauritius and abroad. And that was one of the assurance of international users of the Act, that their applications will be heard by eminent jurists and they will be dispensed of quickly.
Thank you.
I think just to add that there's a similar regime in Nigeria, but not a provision or a force of the legal framework in terms of the law. But most courts in Nigeria designate some judges or some courts as ADR judges or arbitration judges that specifically handle matters relating to arbitration.
Okay, actually, I was asking you the same question, so thanks for anticipating the question. And what about Leyu in Ethiopia? The judges are they specially trained in any form to arbitration?
No, the judges in Ethiopia, are not particularly trained in arbitration, but our Supreme Court judges are highly experienced judges that have been on the bench for a amount of years. And unfortunately, like I mentioned earlier, international arbitration enforcement or even challenges related to international arbitrations mainly happen if the seat is Ethiopia, right? And that doesn't usually happen because the seat is usually outside of Ethiopia. And that, I believe, is the case for a lot of international arbitration cases concerning African parties, hence why the practice of the judges are quite limited in that space.
Thank you. Okay. I propose that we move to the next topic. We will be able to revert to that one with the questions at the end. I have actually questions that I'd like to ask you guys, but I will probably wait till the end of the session. So now moving to the second topic, which is interim measures and state courts, mesures intérimaires et juges étatiques. In choosing this topic, it's actually very diverse. You can look at it in many angles. It's either the interim measures which are being taken by arbitral tribunals and how they can be enforced. That's also the measures you may seek before state courts and the interaction between both. So it's quite rich. I will now turn to Abayomi, and I think you have some slides also. So please, floor is yours. You're on mute, Abayomi.
Sorry, my apologies. So the intervention of court in arbitration through the grant of interim measures is one of the highly debated issues within the arbitration community in Nigeria, given the provisions of Section 34 of the Arbitration and Conciliation Act, which I referred to in the other session. Now, the courts have interpreted this provision as a mandatory provision that excludes judicial interference and as one which does not accommodate a flexible interpretation. Typically, applying for interim measures may likely give rise to at least 2 questions. The first question is, should a party seeking interim measures make the application to the arbitral tribunal or to the court, and is the option of applying to the court instead of the arbitral tribunal a breach of agreement to arbitrate? Now, in Nigeria, while the powers of the arbitrators to grant interim measures in arbitral proceedings are expressed, there are a lot of uncertainties on the powers of the court to grant interim measures in aid of arbitration. Section 13 of the Arbitration and Conciliation Act imbues the arbitral tribunal with the power to make interim orders directing either of the parties to preserve any property relating to the dispute in the arbitral proceedings pending the completion of the proceedings. However, the issue whether Nigerian courts can grant interim measures in arbitration remains unsettled, given that there is no substantive provision in the Arbitration and Conciliation Act that allows the courts to grant such interim measures. So the attitude of Nigerian judiciary to applications for interim measures can conveniently be categorized into two schools of thought. The first school of thought believes that a court can only grant an injunction in support of arbitration if the entire issues in dispute between the parties are brought before the court. This school of thought believes that an action which is instituted for the sole purpose of obtaining an injunctive relief pending the hearing and determination of an arbitration is bound to fail because the court's jurisdiction to entertain such a suit can only be invoked where the entire issue in dispute is brought before the court. Now, the judicial authority in Nigeria, which is usually cited in support of this school of thought, is the case of N.V. Sheikh and M.V. Harris. Now, the Supreme Court of Nigeria in that case held that a court would only be able to grant an interim measure in support of arbitration where the issues in dispute between the parties have been submitted to the court for its determination. In this case, the court refused to grant interim measure for security in support of an arbitration proceedings in London because the claimant in that suit had not submitted the issues in dispute between the parties for determination of the court. The court held that the admiralty jurisdiction of the Federal High Court in Nigeria can only be validly invoked for the sole purpose, or cannot be validly invoked for the sole purpose of obtaining security for an award in respect of an ongoing arbitration in London. And the court ruled that the claimant ought to have approached the arbitral tribunal for an order for interim relief, since the arbitral tribunal was responsible for determining the issues in dispute between the parties. Now, on the flip side, the second school of thought believes that a court has the power to grant an order of injunction pending hearing and determination of the arbitral proceedings, relying on Section 6 of the Constitution of the Federal Republic of Nigeria, which gives every court the inherent power to grant injunctive reliefs. And this school of thought believes that the power to grant injunctions pending arbitration should only be exercised in rare and deserving cases. And one of the precedents that is usually cited or relied on for this second school of thought is the case of M.V. Lupex and NOC Hex. And in that case, the Supreme Court of Nigeria held that a party to an arbitral proceedings will only be permitted to institute an action for injunctive relief in court during the pendency of an arbitral proceedings where there is a strong, compelling, and justifiable reason for such an action. So what we are beginning to see from the court in terms of the standard test used for court intervention by way of interim measures is when there's a strong, compelling, and justifiable reason for the court to intervene by granting injunctive reliefs. And this, this decision has been followed in several cases in Nigeria, including one of the recent cases at the Federal High Court where the court held that it had the jurisdiction and power to grant injunctive reliefs in aid of arbitration, but that it will only exercise such in deserving cases. So the court in Nigeria will intervene in arbitration while arbitral proceedings is pending to grant interim measures where there is a strong, compelling, and justifiable reason to do so. Thank you.
Thank you, Abayomi. That's very interesting, the case law you mentioned, and I just wanted to comment on that. The owner of the MV Lupex case you mentioned.
Yeah.
There is actually a very a debate in the between French scholars regarding the possibility for a court to take measures while the arbitration proceeding is underway. And you have various, let's say, opinions, because French law from 2011 is silent really on the issue, and some says that a bit following this case law, that in some very specific and somehow extraordinary circumstances, you could seek measures before the court, before the state court. Although some others say that no, once the arbitral tribunal is constituted, it is the only forum before which you could seek measures. So that's really the debate we have here. So very, very interesting. I will now turn to Suzanne. I don't know if you have slides, maybe that's the next one.
Yes, I do. And I will skip over the introductory bits that I've already spoken on and go straight to the powers of the court to issue interim measures in the next slides. I'll skip over that and go right. It's very interesting to hear the perspectives of Nigeria and of France, because I believe the practice in Mauritius is slightly more nuanced. The Act, the International Arbitration Act that I mentioned earlier, is aligned with the ancestral model law with respect to interim measures, and it provides in section 23 that the Supreme Court has the same power to issue an interim measure in arbitration proceeding as it has in relation to proceedings of court. But the interim measures that the court can render are not defined under the Act, and indeed under the ancestral model law or under Mauritian law, but they have been understood to be the same as those listed in section 21 as the measures that an arbitral tribunal can grant, which include ordering, and these are listed in the next slide. And these include perhaps ordering the a party to restore or maintain the status quo pending the determination of a dispute, an order to prevent harm or prejudice to the arbitral process, or orders to preserve assets or preserve evidence. But what is interesting is that the Act goes beyond the ancestral model law, because the model law, and indeed many jurisdictions, if you could move to the next slide, please. The model law and many jurisdictions are not very clear as to how courts can exercise their powers to issue interim measures, and also on how this power interrelates with the power of the tribunal to grant its own interim measures once a tribunal is constituted. So the Act here, similar to the English Arbitration Act, provides certain principles in section 23 that are meant in my view to demonstrate that the court should only render interim measures in arbitration on an exceptional basis. And what are these principles? First, the court is required to only intervene to support and not disrupt the arbitral process. And one of the interesting cases that the court has pronounced on this is Amana Middle East Holdings Limited, where after an application for interim measures, an interim order was granted by a judge in chambers, whose effect was to restrain one of the respondents from exercising some very wide-ranging powers that it had been granted through a power of attorney by another respondent. This order was returnable before 3 designated judges. I will come to the procedure later on if I have a minute on how interim measures applications are dealt with by the Supreme Court. But the Supreme Court took the view in this case that it could intervene to support the arbitral process because a tribunal had not yet been set up, and two, failure to issue the interim measures requested was likely to undermine the entire arbitral proceedings, and so it confirmed the order that had been granted by the judge in chambers. Secondly, moving on to the next slide. Secondly, the court is required to take into account the specific features of international arbitration. And I find this quite interesting. Even though these features are not really defined, the court takes into account matters such as the fact that the parties are based in different jurisdictions, the fact that they have agreed specifically to go to arbitration and not to court, the fact that they may have chosen a seat of arbitration that may or may not be Mauritius, and the fact that they may have chosen a substantive law of arbitration that, again, may not be Mauritian law. And so the court, in making a decision to render interim measures, will consider all these facts. Another key feature, key principle that the court takes into account is that it is only to act if there's a real urgency. If a party wants to make an ex parte application for an interim measure, then it has to show that the case is one of extreme urgency. And if there is no urgency, then the other parties in the arbitral tribunal have to be notified. The arbitral tribunal has to permit this, and the other parties have to agree in writing for this for this measure to be applied for. Just going back to the case of Amana Middle East that I mentioned earlier, because the respondent here had been given quite extensive powers, which if were resorted to, like I mentioned earlier, would cause harm to the arbitral process, the court again mentioned that, well, the court can interview in this case because it is one of urgency, where if it is not attended to immediately as requested, then it would cause harm to the arbitral process. And the same principle was referred to in Barnwell Enterprises, where a party, one of the parties was intent on going against an undertaking it had given before the arbitral tribunal and exercise its right to sell shares in a way that was going against to undermine the very reason of the arbitral proceedings. And the court considered this quite urgent that it had to intervene to support the arbitral process. Lastly, the principle that the court considers, another principle that the court considers is that it will only act if the arbitral tribunal lacks power or is unable to act effectively. And the ability to act effectively, again, is not defined under the Act, but it could include considering factors such as, can the order that is issued by the arbitral tribunal be enforced in the relevant jurisdiction? Is the order meant to be directed at a third party? For instance, if this order is meant to be directed to a bank to freeze finances, can the arbitral tribunal legitimately issue an order towards the bank that is not a party to the proceedings? And thirdly, can the tribunal be engaged sufficiently quickly in order to prevent the impugned issue? For instance, if it is going to take maybe a month to constitute the tribunal and an impugned issue is about to occur, then a party may likely resort to court than obviously an arbitral tribunal that does not exist. Barnwell Enterprises is one that exemplified this kind of situation. And in fact, in this case, an arbitral tribunal had already been constituted, but one of the respondents served a notice of intent to sell its shares, as I mentioned earlier, and it had given an undertaking before the tribunal not to do so. And the court stressed that it will only act to the extent that it was required and to the extent that the tribunal would not be able to act effectively, quickly enough to prevent harm to the arbitral process. And the court was satisfied that yes, there's a tribunal, but a new event has occurred here that has not been brought to the attention of the arbitral tribunal. And so we are going to issue an order that is going to last for a period of 2 weeks just to maintain the status quo. And then the applicant can go within that period, can make an application before the arbitral tribunal, but the order would only be maintained for a period of 2 weeks. Now, this is contrary to another case of Massilia Limited, where an tribunal had granted an order to stay the arbitral proceedings pending the determination of the Supreme Court on the validity of the arbitration agreement. And before the court made its determination on the issue of the validity of the agreement, the arbitrator made another interim order ordering the applicant, in this case, not to dispose of certain portions of land pending determination of the issue in dispute. Now, what the applicant was asking the Supreme Court was to set aside this interim order of the arbitral tribunal because the arbitrator did not have the authority in the first place to make that order, since after staying the arbitral proceedings, the arbitrator was functioned as official. And the court found that indeed the arbitral tribunal was a proper forum to deal with the question of this specific interim measure, because even though the tribunal had ordered a stay of the arbitral proceedings, the tribunal still had authority to deal with matters that did not concern the stay of the arbitral proceedings. And so the tribunal could indeed validly order the applicant not to sell off that portion of land that was concerned in this case. And therefore, the Supreme Court was quite reluctant to intervene to set aside the interim order of the Arbitral Tribunal. And this, in my view, demonstrates how much the court is reluctant to intervene in the arbitral process as long as the tribunal has power to act effectively. And lastly, just on a point of procedure, is that all applications for interim measures to the Supreme Court in Mauritius are heard in 2 stages. The first stage is that a judge in chambers is going to entertain an application for interim measures. And this is so that all applications can be heard effectively and quickly. It will be heard in chambers. The judge in chambers is going to make an initial determination. And then if the application was made ex parte, or the parties are going to be served in the tribunal, if it is constituted, is going to be served with the order as well. And then after that, there's a second stage in which 3 designated judges of the Supreme Court, who I mentioned earlier, are going to entertain the application and consider the order that was made by the judge in chambers. They can maintain that order or they can issue a different order. But this second hearing is not of less importance. It is actually where both parties are heard fully. And as I said, the order of the judge in chambers can be maintained or changed. And that's what I would wish to comment on this for now.
Thank you, Suzanne, and thank you for the very comprehensive description. And I think it fascinating the various criteria which actually provide a roadmap to parties and to the judges as to in which conditions order can be granted by courts. And it is indeed very much pro-arbitration and reluctant to intervene. So thanks for that. I don't know if Leyu or Mamadou have any comments before we move to the next topic. I don't know, one of you, if you want to.
I have no comments. I will wait until the end to make my general overall comment. Thank you, Clément.
Okay, Mamadou, you started to say something. You have to unmute your mic.
Merci beaucoup, Clément. On m'entend?
Oui, c'est parfait, c'est tout.
Voilà. Juste 2 points de commentaire justement sur la question des mesures provisoires et des mesures conservatoires, ce qui donne l'occasion donc aux juges étatiques de regarder toujours du côté de l'arbitrage et de mettre un pied là-dedans. Et ce que l'on constate le plus souvent chez les juges judiciaires en Afrique francophone, c'est qu'en fait de mesures provisoires ou de mesures conservatoires, il arrive souvent que sous ce couvert-là, le juge étatique s'installe dans l'arbitrage et devienne un obstacle à l'arbitrage. Des exemples concrets, il est demandé avant la mise en place du tribunal arbitral à un juge judiciaire de la localité où le siège est installé de permettre donc, dans le cadre de l'avancée, pour permettre donc de mener la procédure d'arbitrage, de prendre tantôt des mesures conservatoires, tantôt des mesures provisoires. La question fondamentale, c'est quelle est la nature des mesures provisoires et quelle est la nature des mesures conservatoires. Si par mesure provisoire et par mesure conservatoire, le juge judiciaire se trouve l'occasion de s'installer à l'intérieur de la procédure, d'évoquer des éléments de faits qui ont un impact réel sur le fond de la procédure, il ne restera pas grand-chose lorsque le tribunal sera installé. Et lorsqu'ils interviennent sous ce couvert-là, ils anéantissent la procédure d'arbitrage de sorte qu'ayant empiété sur le fond du dossier, sous le couvert de mesures conservatoires, on bloque également la procédure d'arbitrage et on met en difficulté l'arbitrage à ce niveau. Là encore, c'est le sujet majeur du rapport qu'il y a entre le juge judiciaire étatique et le juge arbitre à ce niveau. Et chaque fois que l'on se retrouve en situation de compétition, comme c'est la plupart des cas l'exemple dans nos États, on se trouve visiblement à bloquer le processus de l'arbitrage, à anéantir la convention d'arbitrage et à ne pas donner la possibilité donc à l'arbitrage de se poursuivre à ce niveau-là. On attire l'attention de plus en plus des parties, qu'il faut faire extrêmement attention lorsque l'une d'entre elles ou les deux envisagent, par exemple, de solliciter le juge judiciaire en vue de prendre ces mesures-là. Vaut mieux souvent aller plus vite dans le cadre de l'installation du tribunal arbitral, demander au tribunal arbitral de prendre ces mesures provisoires, de prendre ces mesures conservatoires, plutôt que de s'abstenir de mettre en place le tribunal arbitral pour donner l'occasion au juge étatique qui, lui, par le biais d'une intervention hasardeuse, peut anéantir le processus de l'arbitrage.
Merci, oui, c'est tout à fait intéressant de voir finalement un peu à l'inverse le risque que pose la possibilité d'aller voir un juge étatique pour venir au soutien de la procédure, mais en fait ouvrir la porte en fait à une possible intervention qui viendrait, une immixtion qui viendrait perturber le processus arbitral. Merci beaucoup Mamadou. S'il n'y a pas d'autres questions, enfin, on a reçu des questions, mais alors je vais peut-être juste poser celle-ci, et puis ensuite on passera au sujet suivant. Donc, on vous pose une question. Monsieur le ministre Konaté, pourriez-vous aborder, s'il vous plaît, la question du respect de la compétence par le juge judiciaire? Cela vous semble-t-il une menace également à l'arbitrage? Voilà la question. Est-ce que, Mamadou Konaté, vous voulez donner quelques éléments de réponse?
Je veux bien, mais c'est le fond de mon intervention. C'est exactement une question qui vient me parler de mesures conservatoires que j'aborde en abordant le fond du dossier. Mais qu'à cela ne tienne, je pense que cette personne-là est suffisamment consciente des dernières décisions qui ont été rendues, notamment par la Cour commune de justice et d'arbitrage, dans un dossier qui impliquait la société Accor contre l'État du Togo. Et de ce point de vue-là, la Cour commune de justice et d'arbitrage a eu l'occasion de réaffirmer sa jurisprudence de 1996 de manière beaucoup plus implacable aujourd'hui, pour dire de manière très nette que lorsqu'il y a deux situations de compétences qui naissent dans le cadre du règlement d'un litige, une convention d'arbitrage d'une part, et puis une justice étatique, la justice judiciaire qui se saisit de la même affaire, la Cour commune de justice d'arbitrage, en application des dispositions aussi bien de l'acte uniforme que du règlement d'arbitrage, indique aujourd'hui qu'il n'y a aucune possibilité pour le juge judiciaire de prospérer à ce niveau. Il faut qu'il lâche le chemin à la justice arbitrale qui doit prendre le pas. Et qui doit prendre d'autant plus le pas que même quand il s'agit d'évaluer, d'apprécier ou d'affirmer la compétence du juge arbitre à ce niveau, il revient au juge arbitre de pouvoir se déterminer sur sa propre compétence, d'où le principe de compétence-compétence, qui est un principe universel en droit de l'arbitrage aujourd'hui, qui vaut non seulement au Nigeria, mais qui vaut également à Maurice et qui vaut également en territoire au Addis niveau. Alors, à la limite, en lisant cette décision de la Cour commune de justice et d'arbitrage sur la question de la compétence, on peut se satisfaire de la régularité non seulement de l'affirmation de ce principe-là dans le cadre d'une jurisprudence qui a été rendue en assemblée plénière par la Cour commune de justice et d'arbitrage, mais également en 2020 par un arrêt qui a concerné donc Accor et l'État du Togo. Par contre, on peut s'inquiéter. On peut s'inquiéter parce que si vous avez lu le commentaire de Jacques Mestre le professeur Jacques Mestre sur la question de compétence dans cet arrêt Société Accor contre État du Togo, vous devez éventuellement être inquiet dans un autre arrêt qui a été rendu dans un dossier SGS contre l'État du Bénin. Alors, je rappelle simplement que l'État du Bénin avait conclu un contrat portant sur une prestation de service et qui comportait donc une clause d'arbitrage. Et parallèlement à ce contrat, l'État du Bénin avait conclu le même contrat ou ayant le même objet avec la Société générale de surveillance, ce qui fait que le contrat initial, le co-contractant initial a dû attaquer le contrat de SGS, a demandé devant le juge administratif du tribunal de première instance de Cotonou non seulement l'annulation du contrat d'une part, et également l'annulation de la convention d'arbitrage, au mépris d'une convention d'arbitrage qui était inscrite dans le dispositif contractuel. Au même moment que, la justice judiciaire était saisie de cette affaire-là, au même moment, le co-contractant de l'État du Bénin, par ailleurs, donc SGS, avait installé un tribunal arbitral dans lequel l'État du Bénin avait participé. Première instance, la justice administrative a annulé le contrat et la convention. La juridiction d'appel a confirmé ce jugement de première instance. Au même moment, il y a eu une sentence partielle qui a été rendue à la demande de l'État du Bénin pour reconnaître la compétence du tribunal arbitral, ce qui a été affirmé, et une sentence au fond est intervenue. Je rappelle simplement que le siège de l'arbitrage est à Ouagadougou. Du coup, la sentence partielle a été attaquée devant la Cour commune de justice et d'arbitrage, qui l'a annulée au motif de la violation d'un ordre public lié à l'autorité de la chose jugée que la Cour commune de justice et d'arbitrage lie à la décision qui a été rendue par la juridiction administrative. Alors, d'un côté, on affirme de manière très solennelle la règle, le respect absolu du principe compétence-compétence. De l'autre, on admet qu'une juridiction administrative puisse violer une convention d'arbitrage pour rendre une décision de justice, parallèlement une sentence arbitrale, une sentence partielle, qui est annulée au prétexte qu'il y a autorité de chose jugée liée à la décision de la juridiction administrative. Or, on sait pertinemment que cette décision de la juridiction administrative a violé l'existence de la convention d'arbitrage, a statué dans un domaine qui, visiblement, elle n'était pas compétente. En violation donc de ces deux situations particulières, la Cour commune de justice et d'arbitrage prend le contre-pied de l'arrêt Société Accord contre État du Togo. Voyez-vous, dans une démarche sibylline, on a tendance à se réjouir de l'existence, de l'affirmation assez forte de ce principe de compétence-compétence qui lui-même est nié de manière évidente, non seulement dans un contexte où le juge judiciaire intervient, mais il intervient dans un domaine qui n'est pas de son ressort. Il prend une décision de justice qui prospère et cette décision de justice en support permet à la Cour commune de casser une sentence partielle et probablement que la sentence qui est rendue au fond va être cassée pour le même motif à ce niveau. Voyez-vous, je vous en parle, je m'arrête là parce que moi-même, je suis profilé donc pour prendre ce dossier-là pour le poursuivre et je rappelle simplement que la décision de la Cour d'appel administrative de Cotonou a fait l'objet d'un pourvoi en cassation non seulement à Cotonou d'une part, mais probablement d'un deuxième pourvoi devant la Cour commune de justice et d'arbitrage. C'est le seul moyen pour rappeler à la Cour commune de justice et d'arbitrage qu'elle ne peut pas affirmer un principe implacable de compétence-compétence pour nier ce principe-là dans un dossier qui, si on ne fait pas attention, on risque d'avancer d'un côté, là où on recule véritablement. Et c'est aussi ça, les situations dans lesquelles on peut se retrouver lorsque le juge judiciaire n'a pas une vue d'ensemble qui lui permet aujourd'hui de pouvoir être très conforme à sa jurisprudence en tenant compte de tous les éléments du dossier. C'est un puzzle, ça peut passer incognito. En lisant ce dossier-là, en lisant les commentaires dithyrambiques qui ont été faits là-dessus, on n'a pas toujours conscience qu'il s'agit d'une décision du juge administratif qui viole toutes les règles de compétence, qui viole non seulement la compétence-compétence, mais qui viole également les règles de compétence et qui viole l'existence d'une convention d'arbitrage dans le cadre de ce contrat-là.
Merci beaucoup, Mamadou, pour ce commentaire de cette affaire aux implications multiples. I will now turn to the other speakers. I will now turn to the other speakers just to have maybe their thoughts on actually the core points of Mamadou, which was that the competence principle is very often announced and recognized in arbitration national laws. That is a no-brainer. That's for sure one of the main main pillar of any national law, arbitration law. But then in practice, and as we can see from Mamadou's comments on that case, in practice, are national court always really supportive to that principle of competence, or sometimes we would find reluctant judges, sometimes not necessarily in the main judicial centers of the country, but maybe in other areas in a given country. So I don't know if one of you, Suzanne, Leyu, or Abayomi, have any thoughts on that?
Not for me.
Yes, Abayomi.
None for me. I will yield my slot to others.
Okay, thanks.
I mean, on if I may, on competence, if I may just comment on the practice here in Mauritius, is that yes, like in many jurisdictions, an arbitral tribunal may rule on its own jurisdiction, including on an objection to whether on the validity or existence of an arbitration agreement. But there is one important corollary to that principle, and is that the tribunal's decision on its jurisdiction cannot be final, as it is in other jurisdictions as well. In other words, the tribunal can make a preliminary ruling on a decision on jurisdiction rather, but it cannot, as stated by the UK Supreme Court in Dala versus Pakistan, pull itself by its own bootstraps. And so section 27, subsection 7 of the International Arbitration Act allows the Supreme Court to review the tribunal's decision on jurisdiction, positive or negative, upon the application of a party within a certain timeline of that decision. And there has been some cases where the Supreme Court has made a ruling that the tribunal essentially does have that authority to rule on its own jurisdiction, respecting the principle of competence.
Thank you, Suzanne. Leyu, do you have any
observation? Yes, just a quick comment. I mean, and I think I'm going to use it as a segue for the discussion we're going to have later with regards to the enforcement of arbitral awards and the duty of the arbitral tribunal to issue an award that is enforceable. But you know, I think Ethiopia's law is quite similar to what Susan just said about Mauritius. We do recognize competence. However, you know, there's a possibility of review at the Supreme Court. Now, the question of the arbitral tribunal defining its jurisdiction and assuming jurisdiction over a matter is one that has created in many instances a challenge at the very end, because and I'm going to stress again the same point I mentioned earlier, which is the importance of having arbitrators that understand the law of the state. And this is extremely key, especially in assuming jurisdiction. I think this is extremely key because then you might potentially end up issuing an award that will be set aside at the seat. But then I'll make the continuing comments when we discuss recognition and enforcement.
Okay, thank you. I guess my question also relates to the so-called negative effect of the competence principle, meaning that a state court being sized in presence of an arbitration clause should in principle find itself, should just give the tribunal the possibility to rule on its own competence. And obviously, and as Suzanne and Leyu, you stressed very rightly, there is the control, a posteriori control at the end by state courts at the enforcement stage or challenge state, which is a very good transition to the last topic of our webinar today, which is recognition, enforcement, challenge of arbitral awards. Well, in saying that, I'm very well aware that in itself, the topic is very broad, and we could have spent the entire morning only on this point. So this is kind of the natural point of contact, and taking the image I took at the beginning of the session regarding the various points of contact between arbitration and state courts. Well, that's the obvious one that we can think immediately, which is the control either at the seat of arbitration for challenge against the arbitral awards, or at every jurisdiction where the award is sought to be enforced. Well, this is a very wide topic. I will start by maybe you, Suzanne, with your thoughts on regarding the Mauritius market.
Right. Thank you, Clement. Mauritius ratified the New York Convention in 1996 and incorporated it into Mauritian law through the Foreign Arbitral Awards Act, as I will refer to it. And so the two acts that govern recognition, enforcement, and challenge of arbitral proceedings in Mauritius is the International Arbitration Act and the Foreign Arbitral Awards Act. And I will first address awards in Mauritius-seated international arbitrations, and then highlight the practice regarding foreign awards. The Act incorporates Section 34 of the Article 34 of the Arbitral Model Law on recourse against awards with some minor modifications. And these are that, in addition to the standard grounds that we know for setting aside awards, the court may also set aside an award in an international arbitration seated in Mauritius if it finds that the making of that award was induced by fraud or corruption, or that there was breach of the rules of natural justice in the conduct of the proceedings, and or in connection with the making of the award. If you could please move to the next slide. There we go, thank you. But to my knowledge, there has not been an application to set aside an award on any of these grounds. In fact, the first application to set aside an arbitral award in an arbitration seated in Mauritius was made in the State Trading Corporation Limited versus Betamax Limited, or the Betamax case, as I will call it, and I will come back to this case later. With regard to the recognition and enforcement of international awards in cases seated in Mauritius, in the next slide, the Supreme Court stated in the Cruz City case that it will apply the New York Convention. In fact, the court applies the New York Convention in the recognition and enforcement of both foreign awards and awards in Mauritius seated international arbitrations. The Cruz City case that I will come back to later was actually the first case to be heard by the Supreme Court in Mauritius under the system of the designated judges that I noted earlier. What is notable is that awards rendered in international arbitrations in Mauritius are not enforceable as of right upon the expiry of the time limits for challenges, which is 3 months, both under the Act and under the model law. Section 40 of the International Arbitration Act states that the Supreme Court will hear applications for enforcement of international awards under the Foreign Arbitral Awards Act, that is under the New York Convention regime, even though it was a Mauritius seated arbitration that is not considered a domestic arbitration. And while this is not an arbitral model law provision, obviously, Mauritius has chosen to make use of the possibility given under Article 1.1 of the New York Convention to submit arbitral awards not considered as domestic awards to the regime of the New York Convention. And why is this? The reason why Mauritius chose to use this route is because, well, first, the notion of enforcement of and recognition of awards is different from that of the court supervision of arbitral awards that are seated in the country, in a particular state. And what this means is that where an award is rendered in an international arbitration seated in Mauritius and it is to be enforced in Mauritius, the losing party may choose not to challenge it following the strict timeline under the Act, but it could wait until the successful party chooses enforcement, or rather applies for enforcement in a different country or in Mauritius, and then seek to resist the enforcement under the Foreign Arbitral Awards Act, or rather under the New York Convention regime. But a successful challenge, as you know, can make enforcement more difficult outside of Mauritius. It depends on the jurisdiction. Some, such as France, may enforce an award that has been set aside elsewhere. So presumably a party may prefer to entrust the Mauritian court with a decision on setting aside, rather than a court in a different jurisdiction where enforcement may be sought by the other party. A notable provision of the International Arbitration Act is that, and this is not a model law provision, is Section 39A, where a court, the Supreme Court, is empowered to give other directions if it orders the setting aside of an award partly or in whole. And the court could direct, for instance, it could give directions on remittance of the award to the tribunal. It could give directions on the commencement of a new arbitration. It could give directions on the future conduct of any proceedings, or the bringing of any action by a party to the arbitral award on a matter that was subject to the award that was set aside. And what about foreign arbitral awards? The court's principle is that it will not supervise awards in proceedings that are sat elsewhere and not in Mauritius. It will only deal with an application to enforce, recognize or enforce an arbitral award where an application is made under the Foreign Arbitral Awards Act. And a distinction ought to be made between foreign awards and awards in Mauritius-seated international arbitrations, because while some of the provisions of the Act, Section 39 and Section 40, apply both to the setting aside and recognition and enforcement of awards in Mauritius, only Section 40 applies to the recognition and enforcement of foreign awards. And why is this distinction important? It doesn't, first, the Supreme Court has pronounced itself on why this distinction is important in two cases. In PAW Italo Segato, that is now on your screen, the court noted that reference to Section 39 of the International Arbitration Act that deals with setting aside for purposes of refusing enforcement of an order in a case that was not seated in Mauritius is misconceived and inappropriate, because the provisions of Section 39 on setting aside apply only to proceedings that are seated in Mauritius. And so for an international, rather for a foreign order, if a party wants to seek to resist enforcement, then it has to go through the New York Convention regime and use the grounds under Article 5.2 of the New York Convention. And while this distinction may not appear very significant because of the similarity of the grounds for setting aside of an award under the International Arbitration Act and for refusing enforcement under the New York Convention, on the other hand, it's quite important in Mauritius for two reasons. First, as the court mentioned in the Cruise City Grant, please go back to the previous slide. It's quite important in Mauritius because, as I mentioned earlier, the court has taken the view that supervision of international awards is different from, conceptually, it's different from the concept of recognizing and enforcing a foreign award, which is governed by the Foreign Arbitral Awards Act. So the court stated that if a seat of the arbitration is elsewhere, application for setting aside or annulment of the award can only be made to the court of the juridical seat of the arbitration. And again, the court of the seat has certain powers to grant, that is granted by national legislation, and these may vary from state to state. For instance, in Mauritius, as I mentioned earlier, the court may set aside an award on grounds that are different or additional to those of the ancestral model law, that is fraud and corruption and breach of the rules of natural justice. And secondly, in a Mauritius-seated international arbitration, a party ought to be aware that it retains the right to resist the recognition and enforcement of an award under the New York Convention regime, even after the expiration of the challenge deadline that is set under the International Arbitration Act. The Mauritian court's deference to the courts of to the supervisory power of the court of the seat is, in my view, exemplified in the Cruise City case, where the seat of that arbitration was England, and the applicant sought enforcement of the arbitral award in Mauritius. The respondent opposed or sought to oppose the enforcement on the ground that the arbitral tribunal had exceeded its jurisdiction. And the court held that under Article 5 of the New York Convention, the supervisory court of the seat had the power to review the arbitral tribunal's jurisdiction, or rather finding on jurisdiction. So the court in Mauritius, unless there are exceptional circumstances, it will not re-verify the issue of jurisdiction where it has been considered and rejected by the court of the seat, in this case, the Court of England, which had already heard and dismissed the jurisdictional objection. I might pause there for now, and if there is some time later, I can deal with how the court in Mauritius has addressed the issue of public policy as a ground for setting aside or for refusing enforcement of arbitral awards. Thank you.
Thank you very much, Suzanne. And now I turn to Abayomi. I think that's your turn, and then that will be Leo. Abayomi.
Thank you. So judicial intervention in arbitration reaches a crucial stage once an award has been issued by the arbitral tribunal. And you will all agree with me that an efficient enforcement process is indeed useful and intrinsic to the growth of arbitration in any country. Now, under the Nigerian regime, the Arbitration and Conciliation Act applies to both domestic and international award. There are three ways for enforcing arbitral awards in Nigeria. First, an award can be enforced under the Foreign Judgment Reciprocal Enforcement Act. An award can also be enforced under the regime created by Section 51 of the Arbitration and Conciliation Act. And thirdly, under the New York Convention made applicable by virtue of Section 54 of the Act. Now, the Arbitration and Conciliation Act also provides a regime for annulment and setting aside of arbitral award. So, an aggrieved party, who's aggrieved by an arbitral award may within 3 months from the date of that award, file an application before a court in Nigeria for setting aside that award on the grounds that the award contains decisions and matters which are beyond the scope of the submission to arbitration, that the arbitrator misconducted himself or herself, that the arbitral proceedings or award has been improperly procured. Now, out of all the grounds by which an arbitral award may be set aside in Nigeria, the ground of misconduct has been subject of constant abuse by losing parties, due largely to the fact that the Act does not define what misconduct is. Well, under the common law, misconduct may imply some sort of irregularity, and Nigerian courts have also helped in a way to provide some clarity on what may constitute misconduct. But there is no, precedent in terms of binding precedent on what misconduct is, and this is actually subject to abuse. And a case to exemplify this, and I'm sure most of the audience will be, eager to hear this case. And that is the recent decision of the Lagos State High Court in Global Gas against Shell, where the High Court in Lagos set aside an ICC award based on the alleged misconduct of the arbitrators. Now, looking at the factual background, the dispute arose between the parties from an alleged breach of a gas sales and purchase agreement. Global Gas, in that case, the applicant commenced an ICC arbitration, and during the arbitral proceedings, Global Gas challenged the appointment of the president of the Arbitral Tribunal on the ground that the president or the chair failed to disclose potential conflict of interest that may have compromised his independence and impartiality. And the ICC Court of Arbitration reviewed that application and dismissed the challenge. So the arbitral proceedings continued, and there was an award against Global Gas, which was issued sometime in 2017. Now, Global Gas filed an application after the award had been rendered, filed an application before the Lagos State High Court, seeking an order setting aside the award on the ground of misconduct. And that misconduct was based on 2 planks. And the first plank was that the president of the Arbitral Tribunal failed to disclose that he had given an expert opinion as a barrister in a case against Shell. And on the second plank, that the president of the Arbitral Tribunal and a co-arbitrator were both members of the governing board of an arbitral institution that the counsel to Shell is also a member of that arbitral institution, governing board of that arbitral institution. Now, in determining the application and setting aside that ICC arbitral award, the Lagos State High Court held that, well, erroneously, in my view, held that an arbitrator who has been challenged ought to resign from the proceeding instead of resisting the challenge, whether or not the information in fact did not amount to conflict of interest. The court held that arbitrators must exercise a duty of care in all cases brought before them so as to dispel any doubt as to impartiality and independence of the arbitrators and to uphold the parties' confidence in the arbitral process. And this goes to what Leo has said in terms of training of judges and the expertise of judges. With due respect to the court, because I think this is quite erroneous, the judge assumed that once an application has been brought to challenge the independence or impartiality of an arbitrator, that the arbitrator should accuse himself, whether that application is substantiated or not, whether it has good grounds or not. The arbitrator should accuse himself. Even when the IBA guidelines on conflict of interest was put before the courts, the court refused to be persuaded by that IBA guideline. But this case, I've had discussion with different people asking about this case and the current disposition of the court in Nigeria to enforcement of award. And what I've, kind of discussion is that this case is not definitive of the disposition of Nigerian courts to enforce an arbitration. It's just a one-off. So Nigerian courts exercise pro-arbitration approach, and Nigerian courts will, enforce arbitral award. And this is just one of those one-off situations. But in the course of acting for multinationals, enforcing awards in Nigeria, there are some challenges that typically come up, which are just thought to identify. And next slide. Okay, the next one. Thank you. So one of those challenges is the one that relates to computation of time for enforcement action. And the question is, when does time for enforcing an arbitral award, when does time begin to run for the purpose of enforcement? The question is whether the limitation period for the purpose of enforcement will start from the date of the accrual of the cause of action, the initial cause of action, or from the date of the breach of the implied term to perform the award. This has been hotly debated within the community, arbitration community in Nigeria. And frustratingly, the Supreme Court of Nigeria has held that for the purpose of enforcement of an award, that the limitation period will start to count from the date of the accrual of the cause of action. Even though this has been corrected in the new Arbitration and Mediation Bill before the National Assembly now, but this is one of the typical concerns that are shown in the cause of enforcement award in Nigeria. The second concern is the status of the enforcing court. Now, the Arbitration and Conciliation Act defines a court to include High Court of the State, High Court of the Federal Capital Territory, the Federal High Court. Now, the interesting thing is that each of these courts has different subject matter jurisdiction. And the argument is when you're enforcing an award, should the subject matter of the underlying dispute, should the underlying dispute fall within the subject matter of each of these courts before the court can exercise jurisdiction in enforcing the award? This again has been subject to different debates, and we're seeing different arguments come out from the arbitration community. And the third is, of course, which anybody that's talking about Nigeria and enforcement say there's long delay in enforcing award in Nigeria. We're beginning to see a different approach, but the concern relates to the frivolous appeals and actions against enforcement proceedings. Often, losing parties file appeals against orders made by enforcing courts And some even think the end of arbitration is the beginning of litigation, thereby making mockery of the principles underlying the arbitration in the first place, being a fast and efficient mechanism for resolving commercial disputes. Some cases where, that took about 15 years, on appeal before an award could be enforced, which is unfortunate. And there's a popular case of IPCO and NMPC, where the English Court of Appeal echoed its frustration and said that the Nigerian judicial system has not kept pace with the need to give effect to the principles underlying the New York Convention. Well, this case was decided some years ago. The approach is different. Things are getting better. The judges are becoming more knowledgeable, and we're beginning to see more, disposition to, enforcing arbitration agreements and enforcing an award. And I just thought to draw, a curtain on my, intervention in this session, in this particular session, by referring to the words of Chief Justice James Hobson, is the Chief Justice of Australia. Next slide. So he said that the courts have an important role to play through intervention at various stages of the arbitral process. The intervention is unavoidable. In the absence of such intervention, the fair resolution of dispute before a tribunal without unnecessary delay or expense will not be achieved. But he concluded by saying that whether court intervention is viewed as supporting or interfering with the process will likely depend on a number of factors, including the timing, the manner, and the degree of such intervention. Thank you.
Thank you, Abayomi, for the very compelling presentation of the regime and the Nigerian law. I will now turn to Leyu, and just to mention that we have also questions that we'll try to address afterwards. Leyu, the floor is yours.
I have a quick, thank you very much, Simon. I have a quick 4 points that I'm going to be making. The first one is some news with regards to Ethiopia, which is we have just signed the New York Convention, which is something we were hoping would happen for quite some time. So New York Convention has been signed, and the law domesticating the New York Convention proclamation has been passed in April, I believe. And so we are just awaiting procedures for ratification. The second one is Ethiopia is currently reviewing its Arbitration Act, and that it is in the process of, I'm very much involved in both these processes, and I believe the new act is going to be one that will increase practice and make it an even better space for arbitration. Now, I'm going to get back to the case that I had mentioned earlier with regards to the Cellini versus the AAWSA AUSA case. And I think if there's interest in understanding the interference or even like the kind of the interactions between state courts and arbitral tribunals, there's a fantastic, very well written on the award. It's very well discussed on a theoretical level in terms of what the role of state court is and what the arbitral tribunal is meant to do. I think the theoretical discussion is fantastic, albeit disagreeing with how the arbitral tribunal applied it. Now, I'm going to mention one important thing which I mentioned earlier, which is the arbitral tribunal, based on different rules and the different arbitration centers, certainly one in the ICC, has a duty to its parties to issue an award that is enforceable. And this should not be seen as a paralyzing duty, but one that encourages the arbitral tribunal to really consider what the impact of the award that they will be making will be based on for the recognition and the enforcement part. And in doing so, I want to review one particular case, which is the Konsa JV case with the Ethio-Djibouti Railway. Now, it's in our laws, Ethiopia's laws are quite similar to the Mauritian laws. I think it's the only country that has an eclectic system, which is a mixture of both the common law and the civil law. And Mauritius and Ethiopia have quite a bit of similarity. And earlier, I heard Susan mention that fraud could actually be a standard to review arbitration awards. Now, the Ethiopian courts have a very different approach to that, which is, yes, you can use fraud as a means to review awards, to set them aside, actually. But the nationality of the award is based on the seat, obviously. Now, if an arbitration award is, if an arbitration is actually seated in Addis, then the assumption is that that the award is obviously an Ethiopian award. And in the Ethiopian context, that means that it is a domestic award. Despite the fact that there could be a foreign element in the dispute, it doesn't automatically make it an international award. The nationality of the award is based off of the seat, right? So in the Consta JV case, this is something that came out quite clearly because in that dispute, the parties, the respondents, had alleged fraud. Now, this was a claim that was dismissed by the Arbitral Tribunal. And in dismissing this, the Arbitral Tribunal did not understand, without necessarily fully reviewing it, did not understand the impact that it could have. Now, after the award was rendered, the parties took the case to the Ethiopian Supreme Court and claimed that because the arbitration was seated in Addis Ababa, it is a domestic award, and as per domestic awards, as an Ethiopian award, fraud can actually be a standard to set it aside, which in fact happened. And, which I had the opportunity to speak to the arbitrators later, and which was kind of a surprise to them. And so I'm going to go back to stressing the fact that it is extremely, extremely important that we appoint arbitrators, whether it is center appointed or party appointed, that we appoint arbitrators that have a very serious knowledge and understanding of the law of the sea, because they could, in a way, be contravening their own duty to issue an enforceable award by not considering claims or even reviewing claims in a more detailed way, by just simply dismissing them. And this could be a challenge to the award later. So I think this is something that we need to review. But finally, what I kind of want to have a bit of a takeaway from me from this point would be that as much as there needs to be a considerable amount of work to be done with regards to creating an understanding among judges on the role of state courts in arbitration, there is much work that needs to be done on the side of the arbitrators to stop looking at courts, particularly courts from developing countries, as interference instead of courts that are going to be supporting the enforcement. I'm going to go back to the case that Abayomi mentioned, with the Shell case. I think in my view, the judge made a very sound and reasonable. The challenge was quite sound, and I think the judge made a sound and reasoned argument in her decision. So I think we need to consider what our courts are saying, and in order to understand what our courts are going to say, we need to appoint people that know how our courts think. I think that's kind of the basis of what I was trying to get at. Thank you, Clément.
Thank you, Leyu. Thank you very much. Now, we are coming to the last part of our session, the Q&A. Before taking the questions, because we have already some questions on the Q&A box, and I have also gathered some questions on my end. I don't know if you have any other comments to make. I don't know, Mamadou, est-ce que vous souhaitez peut-être ajouter quelque chose sur la question des recours contre les sentences arbitrales, sur ce qui a pu être dit ou ce qui vous paraît important du point de vue de la zone OADA également?
Oui. On a au moins un avantage sur les autres en ce qui concerne la zone OADA, c'est qu'on a une place unique à partir de laquelle 17 États partis sont à la réception d'une sentence rendue en OADA. C'est un avantage, mais là encore, cet avantage peut se trouver quelque peu annihilé par une réaction négative du juge judiciaire en ce qui concerne l'exécution de la sentence ou en ce qui concerne le contrôle de la sentence, lorsque ce contrôle lui incombe, par exemple. C'est toujours sous le couvert, justement, d'une intervention à minima qui permet donc au juge judiciaire de lancer un regard sur la sentence en ne comprenant pas toujours que même dans l'hypothèse d'un contrôle post-sentence, il n'est pas demandé au juge judiciaire de se substituer à l'arbitre. Il lui est demandé simplement d'appliquer la loi au regard des éléments de conditions qui lui sont fixés aujourd'hui pour assurer le contrôle de la sentence. Le contrôle de la sentence ne veut pas dire rentrer dans les éléments intrinsèques de la sentence pour se substituer à l'arbitre, à la limite, exercer un pouvoir de recours comme si on était dans le cadre de la justice judiciaire. Ce point est d'autant plus important que ça pose la question de l'autonomie de l'arbitrage par rapport donc à la justice judiciaire. Ça pose la question de l'option que font les parties pour aller en arbitrage plutôt qu'en devant le juge judiciaire. Et cette démarche doit être une démarche totalement distincte dans l'esprit du juge judiciaire, et cette démarche doit être également une démarche totalement préservée par le juge judiciaire, de manière à ce qu'il n'y ait aucune incidence à ce niveau. Alors, je ne sais pas si j'ai l'occasion de parler des procédures incidentes en ce moment ou pas.
Oui, bien sûr.
Alors, toujours justement sur le comportement du juge judiciaire. Quand on parle souvent des rapports avec le juge judiciaire, il faut savoir que le juge judiciaire, c'est à l'extensif aujourd'hui. Le juge judiciaire, c'est souvent le juge fiscal qui intervient donc sur une démarche liée donc à la fiscalité pour intervenir en violation d'une convention d'arbitrage. Et le juge judiciaire, c'est aussi le juge administratif, comme l'exemple que j'ai donné tout à l'heure, en ce qui concerne le Bénin. Mais particulièrement, nous assistons aujourd'hui à une intervention du juge pénal, très peu en amont, mais beaucoup plus en aval, en phase de contrôle de la sentence. Et très souvent, nous assistons aujourd'hui à une incursion de la justice pénale en ce que, aujourd'hui, les actes qui sont mis en cause sont considérés comme étant des actes de corruption, des faits de corruption qui viennent donc anéantir au nom de l'ordre public une sentence qui est rendue. Alors, il y a beaucoup de décisions qui aujourd'hui font l'objet d'un recours en annulation, et le motif principal de l'annulation, c'est que des actes de corruption ou des faits de corruption sont venus aujourd'hui polluer la décision qui est constitutive de la sentence à ce niveau. Là aussi, sur ce point-là, la Cour commune de justice d'arbitrage a eu l'occasion d'intervenir, et il ne faut pas que cette démarche de mise en cause de la sentence, au motif qu'il y a des actes de corruption qui sont mis en cause, soit une démarche systématique, parce que c'est une démarche qui peut annihiler complètement l'arbitrage à ce niveau-là. Donc, sous le couvert de la fiscalité, très peu, sous le couvert du droit administratif, très peu, mais surtout sous le couvert de la justice pénale, des procédures pénales, on a tendance à prendre en otage la sentence arbitrale, on a tendance à mettre en cause la sentence arbitrale, et très souvent, quelquefois du moins pas très souvent, la Cour commune de justice d'arbitrage a répondu favorablement justement à ces attaques-là en ce qui concerne les faits de corruption. Je ne sais pas trop si au Nigeria, ce sont des éléments qui sont avancés. Je ne sais pas non plus si c'est le cas au niveau de Maurice ou au niveau de l'Éthiopie. J'aimerais bien savoir un peu quels sont les exemples, si la question du droit pénal est posée à ce niveau pour anéantir la sentence, et si le support du droit pénal poursuivi se rapporte donc à la corruption, au fait de corruption.
Merci Mamadou. Je vais en profiter pour du coup poser la question à nos autres intervenants. I switch to English. Mamadou is wondering whether in your jurisdictions allegation of fraud and more generally criminal law questions are a valid ground for setting aside arbitral awards, and how, if yes, and how it is taken into account by state courts when such allegations are made. do you have maybe examples or any thoughts on that point? And I turn to anyone who wants to take the mic, actually.
I will take the mic quickly and answer Mamadou. Oui, effectivement, en Éthiopie, c'est le cas. En fait, l'arbitrage dont je viens de discuter, c'est constat adjusé concernant un cas de Ethio-Djibouti Railway, où oui, le cours a intervenu parce qu'il y avait non-corruption, but fraud. Mais en fait, c'est vraiment quelque chose que les cours, enfin en tout cas, les cours étatiques prennent très sérieusement et qui leur permet de revoir même l'arbitrage, enfin la sentence arbitrale finale.
Merci. Et c'est vrai que j'en profite pour... enfin, ça résonne évidemment aux praticiens du droit français de l'arbitrage avec la jurisprudence de la Cour d'appel de Paris qui, on le sait, a évolué de manière assez significative ces dernières années. Et lorsque des allégations de fraude sont faites, eh bien, le contrôle opéré par le juge de l'annulation, il est beaucoup plus important. La juridiction de contrôle va regarder les éléments de droit et de fait de manière approfondie pour déterminer si eh bien, la sentence peut être accueillie. Donc c'est un sujet qui est évidemment extrêmement d'actualité. I don't know if Suzanne or Abayomi, you have a point on that. If not, I have also questions. Abayomi, yes.
Just a quick point to add, even though I can't speak French, is that public policy is one of the grounds for refusal of recognition and enforcement of arbitral award in Nigeria. And I think that fraud can be conveniently argued as one of the public policy in ground exception for refusal of recognition. I've seen 1 or 2 cases in Nigeria where fraud had been emerged and the ground for urging the court to refuse recognition was on the ground of public policy. So that is how it will most likely apply in Nigeria if the award is tainted by fraud.
If I may just add on that, in Mauritius, as I mentioned earlier, one of the grounds that under which the court may set aside an award in a Mauritius-seated international arbitration is fraud and corruption, and secondly, breach of the rules of natural justice. But we have not had occasion where these two have been used as grounds for, or rather invoked as grounds for setting aside of an arbitral award. But like Abayomi mentioned, when it comes to enforcement, even though these 2 grounds may not be applicable in refusal of enforcement, then it can also be invoked as one ground under the public policy ground.
Okay, thank you for the feedback from your various standpoints. Maybe a question for you, Suzanne, that we got from the audience, if I may. The question is as follows. Do you think that the refusal of state courts to enforce an arbitral award, as was done in the Betamax case, can be means for non-independent judiciaries to give out judgments in favor of the defendant's state or state entities? And if so, how do we minimize such a risk?
That's a very strong statement.
Yes.
But what I would say is really like, yeah, I know this is the Betamax case is one of the decisions that is quite well known internationally and that attracted a certain level of discussion and criticism. But like Mamadou said earlier, well, sometimes a single decision can attract too much attention. And I think the state courts in Mauritius which is an up-and-coming hub for arbitration, is the state courts are generally arbitration-friendly. And arbitration-friendly jurisdictions are the responsibility not only of the courts, but of the lawyers and the legal profession as a whole. As all of these features will strengthen the understanding of arbitration in general. So I wouldn't leave it only to the courts, but to the entire, to all the stakeholders of the profession. And like Leyu mentioned, it is key to appoint arbitrators who are knowledgeable and who will interpret the laws, the applicable law correctly. Yeah, so that would be my comment.
Thank you. Thank you. And now, maybe turning to Abayomi, we have a question for you. Actually, getting to a point that Susan mentioned, getting the distinction between post-arbitral proceedings with respect to foreign award on the one hand and international awards on the other, cited in Mauritius in the case mentioned. The question is whether the Arbitration and Concession Act in Nigeria would need to make such a distinction between the set-aside provision in the ACA and whether such a distinction would be something that should take place. Actually, what's your views on that?
Well, thank you. That's an interesting one. Particularly that I'm involved in, in an action now where my law firm is trying to set aside an ICC award. And one of the arguments that has been made in that case is that there is no regime for setting aside international arbitral award in Nigeria, that international award or foreign awards can only be set aside at the seat of the arbitration, and that there's no regime for that. I think today we have two regimes for setting aside of award. There is one under Section 48 of the Act, and there's also refusal of recognition under Section 51. The way the Act is presently drafted, there seems not to be a clear difference between setting aside of an international award and setting aside of domestic award. So typically you rely on that same Section 48 to, when you're, setting aside an award, which is in that case, when I brought the application, the respondent has argued that it cannot be used, that there's no regime for setting aside of an award of a foreign award in Nigeria. I disagree. He has relied on Article 5 of the New York Convention to say, an enforcing court will refuse recognition of award where it has been set aside at the seat, and using that as a basis for, his argument that you can only set aside an award, a foreign award at the seat, and that you can't come to Nigeria to set aside an award. I think largely the issue of setting aside of an award or annulment is regulated by national laws of different countries. There is no clarity in the current legislation as to which one applies to domestic and international. I agree with the person that has asked that question, that there's a need to have clarity. And possibly my case will be the precedent that will, possibly clarify the state of play on whether Section 48 applies to international award or not. Actually, the case is pending, has been set aside for judgments. So I'll definitely let everyone know whatever the judge rules.
Thank you. Sorry, it cuts. Thank you, Abayomi.
Yeah. Can I say something about that question? I just have a quick comment.
Of course.
Okay. This is an actual debate that we're currently having in the lawmaking process of the new arbitration law of Ethiopia. And, this kind of two-pronged approach to domestic arbitration awards and arbitral proceedings versus international arbitration proceedings. And I think for me, it is, when I put my policymaker hat on, right, for me, it's a problematic approach because it has an underlying understanding that in arbitration, our understanding, or we equate non-interference of courts with with the quality of the arbitral tribunal or even the proceeding of the arbitration. Now, if our understanding is that we need to allow more court interference in domestic arbitration proceedings versus international arbitration proceedings, are we saying that the quality of international arbitration is higher than domestic arbitration? And I think this is like a very underlying point that is seldom discussed or mentioned, but kind of, glanced over. And my view is, if our goal in general is to build an arbitration practice that is a good practice, that actually we have great arbitration awards, we have strong enforcement practices, we have strong, court support to the arbitration proceedings. In my view, is we have to merge these two, domestic and arbitration. We have to stop making that difference, and we have to build the arbitration infrastructure based off of having quality awards and having quality proceedings. And having this two-pronged approach is consistently going to have a first-class and second-class citizen type of situation. And I think we really, really need to reconsider that when creating institutions and developing institutions that a lot of African countries are actually currently doing, which is developing practices of arbitration. So we need to create that equal standard for both.
Thank you, Leyu, and that's actually very interesting to have also the lawmaking perspective on the kind of a policy level. And by the way, the future arbitration law in Ethiopia, is it based on the model law in some extent?
No, it's not. It has certain features, but it's actually not based on the model law.
Okay, thanks. Well, I mean, we are approaching the end of this seminar. I will maybe ask you, we use one of the questions we got from the audience, which is a specific question, but that can also be answered more generally. So that's a gentleman from Malawi, and he said that Malawi has not adopted the unilateral model law, nor has it amended its Arbitration Act of 1967. And also Malawi has not ratified yet the New York Convention. And the question is, what do you reckon are the disadvantages to Malawi, apart from the hardship of enforcement of international arbitral awards? And so if I put this question also in the broader context of the African continent, then the question is, I guess, the modernization of national arbitration laws in general. So do you have any comments regarding Malawi or more generally Africa? I don't know who wants to start.
Perfect. I will go because I have to quickly go to another meeting. And I will make this quick comment. We did a research. When you look at the number of countries in Africa that have signed the New York Convention versus the number of enforcement of foreign arbitral awards that have been presented before these countries, before the courts of these countries, you will see that there's a huge imbalance when you look at how many are being enforced, how many enforcement of foreign arbitral awards concerning African parties are being enforced outside of Africa versus in the African continent. And I think this is a huge cause for concern that we should really examine. A lot of African countries have signed, I believe 40 now, African countries have signed the New York Convention. Many of them have signed in the 1960s or up to 1990. And there's a few countries until now that have never had an enforcement of foreign arbitral award presented before their courts. And for me, this is kind of a cause for alarm. The practical approach that Ethiopia took is we signed the New York Convention, and it is very clear on the proclamation that domesticates the New York Convention within the Ethiopian laws. It's clear that on the preamble it says, the reason we signed the New York Convention is to attract investment. So although there is no data, quote unquote, showing that signing the New York Convention will help you get more foreign direct investment, what we see is, when you look at the World Bank Doing Business Index, one of the ticking points that you have on the WB Doing Business Index is, signatory to the New York Convention or not. And the practical approach that Ethiopia took is, well, we don't know if we're going to get enforcement of foreign arbitral awards brought, into Ethiopia, but what we know is the World Bank Doing Business Index, we would like to score higher, so we're going to sign the New York Convention. And we did. And this will perhaps have, more investment attraction opportunities for Ethiopia. But the question of whether the New York Convention, signing the New York Convention means you're going to have more enforcement of foreign arbitral awards being presented to your states, and based on the data that we have collected at IARB Africa, I'm sorry to say it's actually not the truth. And our courts in the African continent are severely underused. And I think there's a stereotype there that we actually need to break.
Thank you, Leïa. That's actually very compelling arguments and practical ones for in favor of ratification of the New York Convention. I mean, I'm very conscious of the time. I don't know if any other speakers want to conclude with just a few words before we stop.
Alors, en ce qui me concerne, juste une petite question qui m'a été posée justement sur le sujet le chantier judiciaire qui est un gros problème en Afrique. Comment aborder donc la méfiance des Africains investisseurs étrangers? Oui, c'est le sujet et c'est le challenge. Et je pense qu'aujourd'hui, l'arbitrage grandira en Afrique ou ne grandira pas si véritablement il bénéficie d'un encadrement judiciaire qui lui reconnaisse, un, son autonomie, deux, son caractère libéral et qui lui donne les instruments qui sont nécessaires et utiles aujourd'hui pour qu'il puisse poursuivre convenablement son chemin.
Merci Mamadou pour cette synthèse, ces recommandations. Abayomi, last word before we separate.
Just to thank you for inviting me to participate in this very important debate. I've enjoyed it thoroughly, and I've also learned some things from the other different jurisdictions, that the panelists are from. Just to mention that, arbitration in Africa is still developing, and lots of, bodies, institutions, Africa Arbitration Academy and different institutions are trying their best to, push that development. We'll get there shortly. It may take time, but we'll definitely get there. Thank you.
Thank you, Abayomi. And for you, Suzanne, some concluding remarks.
Sure, thank you, Clement. And I will make my concluding remarks sort of in answer to the last question that was posed. And my view is that for jurisdictions that have not adopted the model law, well, sometimes the local laws may contain some of the modern principles on arbitration law, such as party autonomy and separability, judicial non-interference, and such. Some of those laws might lack the sophistication that is required for international arbitration proceedings, which sometimes have very wide and far-reaching consequences and ramifications internationally, as we have been discussing in this panel, and that is why it is important. It's an important consideration, and all of these things tie together towards making a jurisdiction arbitration friendly, as we've been exchanging in this panel, and. Yeah, thank you very much for having me on this panel, and thank you to all the participants for listening to us, for asking questions, and to my panelists as well for your interesting and excellent contributions. Thank you very much.
Thank you, Suzanne, and thank you all of you for your really excellent presentation and insights on this topic. I hope you found it interesting this morning. Paris Arbitration Week is going on all the week, so I really invite you to connect and join the various webinars. Maybe a last word to say that AfriCARB, I'm the honor to be one of the co-founder, is very active on LinkedIn and Facebook, so do not hesitate also to join us there. And I wish you a very good day. Thank you very much. Bye-bye.
Bye-bye.